right. Terry M. Davis against Bonnie P. Davis. The appellant ready to proceed.
I would like to reserve 3 minutes for rebuttal, please. May it please the Court, I'm Kristen Adamson, and I'm here today on behalf of the appellant, Mr. Terry Davis, the husband in this case. The facts in this case are not disputed in any significant manner. The parties were married in April 2004, and they were separated on September 8th, 2007. The petition was filed in October 2007, and the final judgment was entered in May of 2009. At the time of the final hearing, the husband was 53. He was permanently disabled. He was not working and was receiving only his United States or his Bell South retirement. The wife was 52. She was a bookkeeper earning $37,000 to $40,000 a year. The only issue before this court that we're requesting reversal on is the award of special equity in the marital home. We submit to the court that this is an error as a matter of law. The court specifically found that there was a special equity. If you look at the final judgment, paragraph 7 and paragraph 8, the court found that there was a special equity in the marital home and based all of the equitable distribution off of this special equity.
Does our decision here, is it based in some part on which version of Section 6107.5 applies?
I believe that regardless of which version of 61.075 applies, the special equity is inappropriate. However, 61.075, the new version, became effective July 2008. The petition was filed in 2007, and therefore, in October 2007, it's a substantive change, and therefore, it is not retroactively applied. So I believe we operate under the old statute. I think it's irrelevant to the outcome of the case, however, in that even under the old 61.075 statute, there was a presumption for tenants of the entireties, which this house was. It was in joint name.
But the trial court could have still made an unequal distribution of the assets.
The trial court could have made an unequal distribution of the assets even under the old statute. However, the court would have had to make specific findings of fact as to why it was making an unequal distribution of the assets, and an unequal distribution of assets would have had to have been pled for. It was not pled for, and there was no finding by the trial court that that's what in fact it was doing. The trial court, on the face of the final judgment, specifically said special equity. That is the term that the trial court used. That is also what was argued before the trial court and is what is contained in all of the transcripts. There was never any argument on either side.
What is your authority for saying that you have to plead for unequal distribution?
Under the cases that have actually allowed unequal distribution, Your Honor, you have had to plead for them. And Stowe v. Stowe, which is the First District Court of Appeals, and these are prior to the new statute as well, specifically said that if there's going to be an unequal distribution, that is something you have to plead for in some manner. And a special equity is an unequal distribution. And personally, I'm very happy we have the new statute, which gets rid of special equities altogether and abolishes them, because they're very confusing. They're confusing to trial courts. They're confusing to everyone.
Even if it's not specifically pled for, doesn't 610751 list out several factors that the judge could consider in making a determination that an unequal distribution would do equity between the parties?
It does. However, all of the cases specifically say that the court must make findings under all of those statutory factors. There were no findings made in that case at all regarding an unequal distribution. What the court found is that there was a special equity, and it basically awarded the special equity, didn't even use the Landay formula, which would have been applicable if there was a special equity. But what the court basically did was say, and there's no disagreement about the numbers, it's only the fact that there's a special equity or not, that the value of the home at the time of the marriage was $178,000, and that there was a $57,000 mortgage on it. Therefore, her special equity in the home is $121,000. And that got cut out and separated out to her as her special equity, leaving the value of the home to be distributed at a significantly different value. It's a $70,000 issue to Mr. Davis, basically. What Mr. Davis argued the entire time was that this house was placed in joint names, and it was done almost immediately. There was a mortgage. Mr. Davis helped to satisfy the mortgage that was placed on the home when they got married within 2 months
And
of
that
their
was
marriage.
$80,000 or
It was
some
the
portion of his
57
$80,000
plus
savings.
16, yes, Your Honor. So that mortgage was satisfied. And then they took out a new mortgage, which they paid on for 3 years together, jointly. And the house was placed in tenants by the entirety. If the house is placed in tenants by the entirety under the old 61.075 or the new 61.075, regardless, all of the case law specifically states that that is a gift presumption. And this has been historic, and it is actually, the gift presumption has increased over the last 10 years to be almost absolute. In order to overcome a gift presumption, you have to present some type of evidence as to how the gift presumption is overcome. The burden of proof was on Mrs. Davis.
Art, are you saying she presented no evidence?
She presented no evidence as to why the gift presumption was overcome. Absolutely none. Other than the only thing she presented was she had paid for it. That was all. There was nothing else. And in review of all of the case law, that is not enough. Simply being the person who paid for the property initially and then putting it into joint names, that does not overcome the gift presumption. That is the gift. The only case that I've found within recent times that overcame the gift presumption was one where all the testimony basically indicated that the only reason that the property had been put, and it wasn't a marital home, it was another home, the only reason that the property had been put into joint names was for testamentary purposes. There was no evidence and no testimony in this case of any kind other than she owned it and now she wants a special equity back. And all of the cases, and several of them are First District Court of Appeal cases, have indicated that there's a presumption that entirety's real property is marital regardless of who paid for it. And the party seeking to overcome the statutory presumption has the burden of proving a gift was not intended. That's Zingari versus Cunningham, Ferrara.
I believe that the wife admits that there's no special equity.
Which is really interesting because that was what the court specifically found, that there was a special equity, and that was what was argued before the court, and that was what the motion for a rehearing was on, and all of what went on at the trial level was based on special equity. And now he does admit in his answer brief that there's no special equity and tries to manufacture why there should be an unequal distribution of assets. But there's absolutely no finding by the trial court in the final judgment or anywhere else as to the statutory factors regarding why there would be an unequal distribution of this asset.
Now, let me ask you, I see from the final judgment that there's not any discussion of the factors in 610751. Did the judge make any pronouncements, though?
No.
About what her factors might have been?
No. The only thing the judge did was say special equity. That's the term used throughout the entire transcript, throughout the entire pleadings and everything. It's only special equity. I don't think this judge was presented with any of the statutory factors for an unequal distribution. She was presented with the testimony of the case, and that's what Ms. Davis is now saying is that, well, he could have done that, but if there was notice that that was going to be the issue, then Mr. Davis could also have put on testimony about it as well. And that was not the findings. There were no statutory factors that were found that way. And even if there were, there's nothing that was presented to this court that would have met that burden. So legally, this needs to be reversed because it's legally insufficient. Factually, there's nothing that supports an unequal distribution based upon this court's finding cases.
So what relief exactly are you seeking?
What the relief we're seeking is a reversal of the special equity for a remand to, and this house being a marital home, because all the testimony and evidence is there. This house is marital. We're requesting that the court find that it's marital, that there's no special equity under the law or facts allowed, and for a equitable distribution based upon that. And it's about a $70,000 issue to Mr. Davis. The amount was $160,000 that should have been, let's see, 106. $212 should have been divided between them, net equity. That's what should have been divided. Instead, what ended up getting divided is $91,000 because of her special equity. So it's a huge issue, and we believe that it was simply an error as a matter of law by the trial court in terms of finding the special equity where none existed in facts or law. I would point to the court the case, and it's a 2009 case dealing with and that is the Stowe v. Stowe case out of the First District Court of Appeal, which specifically said that even if the court made findings regarding the statutory factors in 61.075, and this is the 2007 statute, the original statute that we're operating under, none of those factors actually weighed in favor of an unequal distribution. So even if the court had made findings, which it didn't address it, it wasn't pled before the court, those factors were not acceptable. And those factors in the Stowe case were very similar to the factors that Mrs. Davis is now attempting to attach in her answer brief, and they were the length of the marriage, the desirability of retaining the home as a residence, and the fact that she purchased the home with her trust funds.
But counsel, you're asking us to reverse and remand so the trial court will get to consider those factors?
I'm simply stating the trial court made an inappropriate determination based upon the special equity request, and that was what was before it. So I'm asking you to reverse this as to special equity, and it's a marital home, and there are no factors that were presented to this court at the trial level that would rise to that level of allowing an unequal distribution, which wasn't pled and wasn't tried, and there were no factors, even if the court were to reverse this, there's no factors that would allow that to happen in this case.
So you're asking us to reverse but not remand for further proceedings?
Remand only for the calculations as to the equitable distribution, because now the equitable distribution will change. It will change by a very large number, and that might require something different to happen with the house or some of the other assets. Because Ms. Davis received the entire home, she may not be able to, at this point in time, afford to buy him out of the home. She was allowed to buy him out of the home for $11,000. That number should be more like $60,000 or $70,000. I see that I am into my rebuttal time. I would like to reserve. Thank you.
We do have your position correctly that you concede that it was an error to find a special equity in this case.
Judge, yes. Obviously, I have not argued in my brief that there was sufficient evidence to overcome the presumption of gift. Read way too many appellate transcripts to want to come in and tell you something is there that's simply not in that transcript. This is a very weak transcript, and there's a lot of things left out of this hearing that have actually been talked about in some briefs. There are no arguments in this transcript. There are no arguments in this record. There are no written arguments. And for the record here, I'm Jeff Whitten from Panama City, representing the former wife in this case. There was no discussion of the gift or the presumption of gift in this case, and I have to admit that on this record.
Do you agree with Ms. Adamson that the trial court did not go through any effort at making specific findings as to the factors in 610751?
There are no written findings to that effect, and
I look at the final judgment, I see none. But did the judge pronounce any findings specific to these factors?
There are no pronouncements of record in this case. There's no findings, no oral announcement of the court's findings. At the end of the trial, she said she would send a letter after receiving the written arguments from the counsel The written arguments are not in the record. The court's letter, if it was ever sent, was not included in the record. What we know is what is in the written order. Anything else would be outside the record. I can tell you what trial counsel told me occurred, but I recognize that that's not something that's properly before the court. And I apologize for having to even say that. So,
maybe it should go back so these things can be discussed.
That's a possibility, Your Honor. Certainly, if it goes back, then it should go back with opportunity to plead it and have the trial court fully expound her reasoning in reaching the judgment. It shouldn't go back.
But if it wasn't pled initially, why should we send it back and say, go on and plead it now?
An equitable distribution was generally pled, and I believe that that's sufficient pleading to incorporate all of the elements of equitable distribution, which includes unequal distribution. Equitable and equal are not the same thing. So you're not asking that we would send it back and allow additional matters to be pled? No, I think it's sufficient in the pleadings if it's addressed to the court.
And you are suggesting that we send it back and allow additional evidence with respect to unequal distribution?
I would like to see that if you are going to send it back, Your Honor, that it just go back reopened with the pleadings reopened in that regard and the evidence reopened. But I don't think you need to do that. I think that there's sufficient evidence in this record to show why the decision of the trial court below was fundamentally fair, that this is reviewed like all dissolution of marriages on an abuse of discretion standard, and that this was the final result in this case is well within the trial court's discretion.
There's a requirement, though, for specific fact-finding, isn't there?
Yes, there is.
We can't presume that.
No, we can't presume that. I'm not asking you to presume that. I'm simply asking us or suggesting that, as there is in every case, the judge got to the right place. Her reasoning may have been wrong.
But her reasoning is actually absent.
Yes.
And it seems that the statute requires that she set forth specifically what her rationale was.
Well, I believe the court's rationale was that she thought gift might have been shown, and I can't tell you that she was correct in that rationale. I don't think the court, certainly the court did not expressly discuss alternate rationales. I'm not sure this issue was actually squarely ever presented to the trial court by anybody. And the first issue that I raised in my brief was preservation in this case. I don't know that this issue, I do not believe that this issue was preserved for this court to review because of the lack of anything in this record as to the arguments that were presented to the trial court. There is a somewhat confusing motion for rehearing by Mr. Martz.
Didn't she plead for special equity?
She did plead for a special equity, and that was entirely appropriate in November of 2009 or 2007.
What did he say in his answer about special equity?
He was the appellant. He was the petitioner. There wasn't an answer. The cross-claim denied the request for special equity. Let me get my straight. I'm sorry, Your Honor. He was the petitioner. She counterclaimed for divorce and special equity. His response simply was a denial.
All right. So she pleaded special equity. He denied.
Yes.
All right. So you're saying that the issue was not before the court?
I think it was before the court. I'm saying the issue that is argued to you today was not presented squarely to the trial court in order for it to be something that can be argued on appeal. You don't hear for the first time on appeal issues regarding that are not argued to the trial court. And all we've got that the lack of findings in this judgment or the absence of gift is a motion for rehearing by Mr. Martz. We don't have the transcript on the rehearing. We don't have the arguments on the rehearing. We don't have even the arguments following the primary hearing, the trial. But what you've got is a motion that seems to both argue that special equity doesn't exist and that it wasn't proven, and it kind of mixes the two together, and I don't believe on that you can sit here and say this issue was preserved for review. That's the first point I want to make.
When you say this issue, you're talking about whether or not there was a special equity?
Whether or not my clients established the evidence to prove a special equity.
That's not properly before us.
That's my suggestion, yes, Your Honor, because even that, we don't know what was argued. And this is an Applegate-type situation where parts of the record are missing.
All right, but just to review, the counterpetition pleaded special equity. The appellant denied the special equity.
Yes.
After a hearing, the trial judge found a special equity.
Correct.
The appellant filed a motion for rehearing, complaining about that.
We're complaining about, yeah, the special equity
Here
itself.
we are, and I
Yes.
actually thought you had conceded there was no special equity, and now you're telling us it's not before us.
I had conceded that there was no proof of to overcome the presumption of gift. That is the concession. There was no proof sufficient to overcome the presumption of gift.
Are you saying that the statute was not asserted below?
Judge, I don't know what was asserted below, except in that motion of Mr. March that seems to have it both ways. None of us know because we're bound to the record. I did notice in one thing I do want to correct in my brief, I did have one typographical error.
What counsel, was there evidence introduced on behalf of the wife to rebut the more than a presumption created by the property being titled as tenants by the entirety? Was there evidence introduced? You're saying there was no evidence introduced that it was not intended to be a gift?
That's correct. The parties stipulated that it was in entireties. The record doesn't tell us exactly when it was converted to entireties. It was, I don't want to misstate what the facts were in that regard. It was something on the order of 4 to 5 months after the marriage, and not too long after the payoff from the commingled account of the first mortgage.
Those facts are in the record?
Except for the date of the deed, yes. Those are in the record.
But there's nothing in the record to support a claim that this home is not a marital asset?
That would be correct, Your Honor. There is no testimony from one side or the other as to the intent of the parties in making that transfer.
But here does the husband have a burden? Isn't the burden here on the wife to assert the claim? Isn't that what the statute says?
That's correct, Your Honor, and I am not arguing that she carried that burden below.
Okay.
I have never argued that. I think I conceded in my brief that she did not carry that burden below.
Well, bottom line, why shouldn't the property be equally divided?
Judge, as I've laid out in the brief, there is a substantial disparity in what took place in this marriage. The husband came in, if you add it up, with roughly $500,000 in non-marital assets, and he is leaving with roughly $430,000 in non-marital assets. The wife came in with roughly $145,000, $150,000 in non-marital assets. The equity in the house plus about a $20,000 IRA. That's what the evidence was. She is leaving, it looks like, with the IRA, what's left in it. So that's one issue right there.
And the house.
And the house, if the house, and that is where my point in why this is fundamentally fair is the short marriage, yes, they put commingled funds. There's been a suggestion throughout the brief that the funds were non-marital when they were put into the house. That is not what the judge found. The judge found they'd been commingled prior to that.
How much was in the account before he put in the $80,000?
It mostly came from him. I'm not suggesting it did not. It mostly, if not all. But the court specifically found that account had become commingled prior to paying off the mortgage on the house or putting the $16,000 additional improvement into the house.
But if there's no special equity and there are no specific findings of fact to support unequal distribution, how can we affirm?
Judge, this court can affirm when the decision is fundamentally fair or when none of these issues were preserved. If this issue hasn't been preserved for review,
Oh, but it still
then
has
it
to
gets
follow the law. I mean, we can't just
affirmed.
go like this and say, geez, that really seems fair. I mean, it still has to be in compliance with the very specific law, doesn't it?
Ordinarily, yes, Your Honor. But again, it has to be preserved to the court, and there is no motion that tells the court that this order is insufficient. He just apparently, Mr. March wanted to argue the sufficiency of the evidence. The court hearing him rejected that or didn't reject that. The order on rehearing is just denied. The order both sides moved to clarify the order in any event, because the court's order just left off $23,000 in assets that went to the husband. That's been clarified subsequent to the appeal. A number of things like that, and that's the typo I started to mention. I said at one point in my brief the court evidently meant these to be returned, the husband to return these assets. The court evidently meant the husband to retain those assets, and he did retain those. That's on page 11 of my brief, and I apologize. I did not see that until preparing for this oral argument. There are some specific factual disputes, by the way. One of those is 2 or 3 times in the brief, appellant's briefs, they have mentioned the wife's substantial federal pension and cited 3 pages in the transcript. There was no federal pension, and there was nothing mentioned in those 3 pages in the transcript. The wife was a 5-year Postal Service employee. Had she remained, instead of leaving that job to go play with the husband, as she put it, because he was now retired, then she would ultimately have had a retirement.
So she hadn't vested?
She's not vested, no. And there's no evidence of any value of a federal pension. The second issue, factually, he's on permanent disability from the phone company. As he put it when asked by his lawyer, "Are you disabled?" He said, "Well, according to the phone company." That's a little bit different than saying, "Yes, I'm disabled and can't work." But that's what he said. Those are the points on my notes. I'll yield back my last 55 seconds unless there are additional questions. Thank you.
Thank you, Mr. Wood.
I would like to point out to the court that it's not that the court's reasoning was absent. It's that the court's reasoning was wrong. The court was not looking at an unequal distribution. It was looking at special equity. And I believe that, as Judge Benton has pointed out, it was pled, it was denied, it was tried. That was it. That was what was before the court. The court made findings. They were wrong factually. It has been acknowledged that they were wrong, that there was no ability to get over the gift presumption. So I would submit to the court it must be reversed on the legal insufficiency of the final judgment. Similarly, as far as the reversing it and remanding it for additional evidence, I think that would be very inappropriate as to what happened here. I disagree that the record is not enough. The record is what it is. They put on all of their evidence. The parties' attorneys had the ability to argue whatever they wanted to argue. And in the motion for rehearing that Mr. Martz filed, he specifically told the judge, this is wrong, this special equity thing is wrong, don't do this. And the judge did it anyway. So everything that was there before the court that this determination was made upon was before the court. The court made an incorrect decision legally. And factually, there was nothing to support it. As far as the history of equitable distribution in this state, all of the statutes and all of the cases have a presumption that marital property will be equally divided. That is a huge presumption. It's the presumption that has been established historically, and that presumption is increasing, not decreasing. As a result, it's very difficult, even if we have statutory factors for an unequal distribution, to overcome that presumption. And that presumption, even if we were under an unequal distribution of assets, would still be on the party requesting the unequal distribution. I would submit to this Court that it wasn't pled, and there was no evidence below, based upon the record below, that an unequal distribution would have been appropriate given all of the case law that has dealt with unequal distributions to this point in time. Thank you.
Thank you.